to our Business Legal Management webinar. I'm George Brunt, one of the founders and principals in Business Legal Management. And we have today with us as our guest, Paul Thomas Ivy, who is an attorney with the Business Law Group and an independent professional that associates with the Business Law Group. And Paul, welcome to the webinar.
Thank you.
Paul, why don't you give us a little bit of your background?
I've been an attorney for a little over 35 years, done basically contract law and working various corporations, both as in-house counsel and for law firms. Quite a bit of work has been done with technology corporations.
Great, well, welcome. Well, I can vouch for Paul because we worked together at Alcatel for some time, and one of the best business attorneys that I know. So we'll go ahead and start. I'm going to share my screen, and so we can see the presentation here. So let's just bring that up. There we go. So this is the presentation that we're going to talk through today. We're in partnership with the C-Suite Network, and it's a pleasure to work with them. It's a number of thousands of CEOs around the world who have joined into the C-Suite Network to get presentations like this and to mutually support one another's business. So I'm just going to bring up the slideshow now with the slides. Let's see what happens as here we go. There we are. Paul, why don't you take us through these slides?
All right. Yes, today we're talking about the California Consumer Privacy Act of 2018, commonly referred to just as the CCPA. Thank you. The CCPA was effective on January 1st, 2020, but the deadline for rulemaking is July 1st, 2020. And after the rules have been finalized, then the companies will have to start complying with it. It offers new and wide-ranging privacy rights for California residents, such as the right to be informed about personal data collected by a business, rights to access and delete that information, right to prevent personal information from being sold to third parties, and rights of data portability. It applies to all businesses that collect or use this personal information, not just those companies in California, as long as they meet some additional criteria. And there are going to be penalties for breaching these rights. The California Attorney General can bring actions for civil penalties up to $7,500 per violation. And there's a limited private right of action for individual victims of data breaches with penalties up to, well, ranging between $100 and $750 per violation.
So Paul, if I am a company in Texas, but I sell products in California, and I do it over the internet where people put a personal profile or some sort of information on my website, this applies to me?
Yes, this will apply to you, provided you meet some additional criteria, such as either the size of your company. Here we go. The application, the who or what is protected. It's consumers, devices, and households. The definition of households is a little flexible right now. We're hoping that the California Attorney General comes out with some better definitions. The types of businesses that are affected requires a for-profit entity, and it has to have annual gross revenues greater than $25 million. So a lot of smaller companies will not be affected. However, it's or, not and, but or, a loaner in combination buys, receives, sells, or shares for commercial purposes personal information of 50,000 or more consumers, devices or households, or derives 50% or more of their annual revenues from selling of the personal information. So let's go back for just a moment. For consumers, a consumer is a natural person who is a California resident. So if they're residents outside of California, it does not apply to them. And it's however these consumers are identified, even if it's with a unique identifier, like a username rather than their own personal name. Devices would include any physical object that's capable of connecting to the internet directly or indirectly. So now let's go on to the next slide. There's a number of principal requirements in consumer rights. The first of which is you have to publish a notice of your privacy policies. That's required to publish a privacy statement called a privacy statement, and that has to contain a description of consumer rights, which means the right to disclose the personal information collected, disclosure of sale or transfer of personal information, no discrimination for exercising the privacy rights, one or more designated methods for submitting requests, such as a toll-free number or a website address. The categories of information collected are those collected in the last 12 months. You have to have a list of categories of personal information that you've either sold or disclosed for business purposes in the last 12 months. However, if you have not had any such sales, you must disclose the fact that you have not had any sales. You have to inform the consumers as to their categories of personal information to be collected, the right to have personal information held by the company deleted, and the fact that personal information may be sold by a business and the rights to opt out of such sale. You have to have a link on the home page of the business website, which is titled "Do Not Sell My Personal Information." And the definition of home page is broad enough to include not only the landing page or the home page of the website, but also every web page at which the business collects personal information. You also have to disclose the rights to access personal information. For example, a business that holds personal information about a consumer must disclose the categories of personal information it's collected about the consumer, the categories of sources from which the personal information is collected, the business or commercial purposes for collecting or selling personal information, the categories of third parties to whom the business shares personal information, and the specific pieces of personal information that is collected from about the consumers. Under the rights to delete personal information, it gets a little broad. The consumer may request that personal information that the business is collecting from the consumer be deleted. There are a number of exceptions to this. One is, for example, completing the transaction for which the personal information was collected, or to detect security incidences, and a number that will probably not apply to most companies. The next right is the right to be informed of personal information sold or disclosed. In other words, a consumer has the right to be informed by a business of the categories of personal information that the business collected.
Do they have to ask?
Yes. Well, excuse me. They have to ask for the particular information. However, the categories of personal information needs to be included in the privacy policy.
Okay.
So the consumer has a right to know the categories of personal information the business collected about the consumer, and the categories of personal information the business sold and to whom it was sold, the categories of personal information the business disclosed about the consumer for its business purposes. Then the consumer also has a right to opt out of the sale of personal information. In other words, the consumer has the right at any time to direct a business that sells personal information about the consumer to third parties not to sell the consumer's personal information. So if you aren't selling any personal information, it's a lot easier just to state on your privacy policy that you are not selling it. A business that sells consumers' personal information to third parties has to provide notice to consumers that the information may be sold and that consumers have the right to opt out of the sale of their personal information. So you do have to tell them that they have the right to opt out. And a third party cannot sell personal information about a consumer that's been sold to that third party by a business unless the consumer has received explicit notice and is provided an opportunity to exercise their right to opt out. So a company which provides information to third parties by sale, you would have to have some kind of mechanism for informing that third party when there is an opt-out or a deletion request by the consumer. There are special requirements for an opt-in for children under the age of 16. In order to sell that type of personal information, there has to be an opt-in place. Those under the age of 16, if the business has actual knowledge that the consumer is under 16, it has to have opt-in consent for that minor consumer. For those under the age of 13, a parent or guardian must give consent to the sale. So the ability to determine the age of the consumer is going to be quite important, especially if you may be facing penalties up to $7,500 per incident for failing to do so. There's also the right of data portability. And the Act requires that when a consumer asks for a copy of their personal information, the information has to be portable and to the extent technically feasible in a readily available format that allows a consumer to transmit the information to another entity without hindrance. This could be perhaps a email or a PDF statement of some sort that perhaps helps limit their ability to modify what you've provided them. If you would go to the next slide, please. There's going to be another number.
There we go.
No, it should be the next one, the one titled Secondary Rights. There we go. Yeah, some of the lesser probably applicable rights are the right to no discrimination. In other words, if a consumer opts out of the sale of his or her personal information, you cannot take any measures that might discriminate against them. For example, you can't deny goods or services to that consumer just because they opted out of the ability for you to sell their information. You can't charge them different prices or rates for goods or services if they've opted out. You can't provide a different level or quality of goods or services to the consumer just because they've opted out. Nor can you really suggest to the consumer that they're going to receive a different price or rate or different level or quantity of goods or services if they've opted out.
That's a good protection for the consumer.
Very good protection, but it also means that when you're designing websites and prices, if they have opted out, then you cannot, in essence, take any retaliatory measures against them for opting out.
Right, right. And you may have based your product pricing partially on selling information. So you could end up losing more money on people who opt out, but you still can't discriminate.
Correct. Now, the definition of personal information, it's very broad. It just means information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly to a particular consumer or household. So it's exceedingly broad.
Right.
The personal information includes identifiers such as the real name of the person, an alias, postal address, a unique personal identifier, an online identifier, email address, account name, social security number, driver's license number, or any type of identifier for a person. Now, it does not include publicly available information that's lawfully made available to the general public from federal, state, or local government records. Those can still be retained. The characteristics of protected classifications under California or federal law, commercial information would be included biometric information, internet or other electronic network activity information, geolocation information, audio information. For example, if someone is having their call recorded, that would be included in protected information. Professional or employment related information, educational information. So it's exceedingly broad as to what information.
Mm-hmm.
There's a number of exceptions to compliance with the Act. For example, it's not applicable typically when it comes into conflict with other laws, and especially at the federal level. For example, when a business has to or wants to comply with federal, state, or local laws, or to comply with a civil, criminal, or regulatory investigation, subpoena. So if there's any litigation going on that might encompass the consumer's records, you would not want to modify those records. The CCPA allows businesses to collect, retain, sell, or disclose kind of consumer information that's de-identified or in the aggregate consumer information, and to collect or sell consumers' personal information if every aspect of that commercial conduct takes place wholly outside of California. I would assume that most companies who deal with California, since all of their commercial conduct would not be then taken completely out of California, that's probably a limitation that won't apply in a great deal of places. The Act also doesn't apply where it would violate an evidentiary privilege under California law, or the California Confidentiality of Medical Information Act, or HIPAA, or the sale of personal information as to which the consumer reporting agency, if that information is part of a consumer report governed by the Federal Fair Credit Reporting Act, or if it conflicts with the federal Gramm-Leach-Bliley law, or conflicts with Data or Drivers Protection Act. So there's a number of reasons why it might not apply, but those are fairly limited. Potential sanctions can be quite severe for an intentional violation. The California Attorney General can result in fines up to $7,500 per violation. Now, you can show it was an unintentional violation and you fail to cure the violation within 30 days of being notified, the fine can be up to $2,500 per violation, which is why if you're notified of a violation, you need to quickly resolve the problem.
This is a very stiff fines if you've got 1 million people or 2 million people you have data on.
Yeah, especially if, say, you're collecting information from people age 16 or under 13, you could get an awful lot of violations from those youths who've provided their information. So you need a very strong method of tracking the age of the people.
Mm-hmm. Yeah.
So that's one of the things that probably may need to be bumped up a little. Now, the breach victim themselves can get between, say, $175 or $750 per incident, or actual damages if they can prove actual damages,
so this is not just enforced by the government. They've given a private right to sue to consumers to collect money.
Correct. And that's where you may have to watch out for, say, a class action lawsuit. You might be hit by both the Attorney General for violations and a class action lawsuit on behalf of the individual consumers.
So if the Attorney General brings a lawsuit, it'd be pretty easy for a class action attorney to just piggyback off of that.
Yes.
Interesting.
Yeah. The best way to try to comply with this is first create a data inventory, which is a comprehensive reference system that describes all the personal information collected and used by the business. This may not be easy, but it needs to be kind of the first step. You also need to respond to consumer information access requests by the individual consumers. You only have 45 days to respond. However, before you have to respond, you can validate that the requester is who they say they are. In other words, you don't necessarily have to just accept an email where the person says, I'm Joe Blow and I need you to delete all your information on me. You can ask for additional identifying information from them so that you can pinpoint exactly which person is making the request. Once, however, you've validated the request, you have to locate all the personal information that's in the scope, which is based on a rather broad definition cited in the Act, and then package that data into a usable and portable form and send it to the consumer. This could be done in, say, an email, which would probably be the least expensive method if there's some way of using the system to automatically generate, say, a PDF or attachment for an email. Mm-hmm. That would make it fairly portable. Now, you need to create an opt-out and opt-in mechanism. For the children, that's more of an opt-in, which means that they have to get consent mm-hmm. before you can sell their information. You need to implement a consumer management system to track all of the opt-out and opt-in requests. If you have such a system, it'll help you prove you've honored the requests so that you can refute charges for
Right.
Then you need to update your consent mechanisms related to children's personal information. Generally, businesses that collect personal information of children under the age of 13 are already subjected to the Children's Online Privacy Protection Act, otherwise known as COPA, which is based on federal law. However, the CCPA adds additional requirements related to those under 13, and you need to update your consent management mechanism to incorporate these additional requirements. Then you need to update your business privacy statement. You need to publish detailed information about your privacy practices via your website or other online presence. You need to provide a do not sell my personal information link on the home page or any landing page. The definition of home page is quite broad. It not only includes what you would think of the home page of a website, it also includes every web page on which a business collects personal information. And you need to provide notification to consumers about categories of information collected and related purposes, the right to have their personal information deleted, that personal information may be sold, and the right to opt out of such sale. Some of the information you probably already have on your privacy statement, such as the categories of information collected and related purposes, but the fact that you may be selling information and the right to opt out of the sale is probably, and the right to have personal information deleted is probably not or may not be currently in your privacy policy. You need to review the incident reports and breach notification policies and procedures. Your ability to cure a breach means to minimize potential penalties, necessitating updated policies and procedures.
Mm-hmm.
So by doing so, it helps give you an argument that you should not be fined as requested. And you need to address the portability of and the right of data portability includes data provided knowingly and actively by the data subject, which means the consumer, as well as the personal data generated by his or her activity on the website. So this includes not just data provided by the consumer, but also the transactional data that goes along with it.
That's very interesting. That could require a whole new set of software.
Correct.
Well, does your firm do these update people's privacy statements and policies, review their policies and procedures, and try and help them be in compliance with things like this?
Yes, we can do that.
And I'm sure the important thing is not who you use, but any law firm can do that. But certain law firms will know more about privacy and about these types of rules than others. Well, good. Well, is there anything else?
Well, I would like to point out that the California Attorney General's office has held 7 public forums to get feedback regarding the law. And the California Attorney General is in the process of trying to update the law and the rules. And the major areas where the changes have been requested are the limitation on the definition of consumer, including household. That was a sticky issue because you don't want to have one person or one consumer in a household delete all of the information for the whole household, right. And others may want to have that information kept. Another issue was guidance on how to actually identify consumers 16 years or younger. how to determine if a consumer is a California consumer or just a transient in California. Say somebody takes vacation in California and they order something online, but their home is really someplace else, so they're not a California resident. How do you determine whether or not the law applies to them?
So
Then
I get from what you're saying that there's still a lot of refinement to be done on this. Is it in place right now, or when does it become effective that companies have to be doing this?
Well, the latest information that I've been able to gather is that 12 months after the final rules have been published is when everyone needs to be compliant. And the final rules have not yet been implemented. They were supposed to be implemented, I believe, July 1st of this year, 2019, but that has not happened, I think, because of the extensive nature of the issues that businesses had with the rules.
Right. Well, it's been very informative. It's been very helpful to kind of see what's coming down the pike and what people are going to have to comply with and the kind of penalties people are going to have to face if they don't. So it's a pretty serious effort. It's like the year 2000 in a way. You have to retool your systems and make sure your policy and procedure is in place.
Yes, and if you wait till the last minute to try to implement all these changes or to even start finding out what information you have and where it's collected, it will probably be too late if you wait.
Right, and California is one of the largest economies in the world, so it's most businesses sell to California consumers.
Yes.
Or at least many do. Yeah.
Yes, and even though the threshold is for a company that has $25 million in sales, I believe there are a tremendous number of companies who are going to fall under that.
Right, right. Or the other two categories where they collect information on a number of consumers or they sell information on a number of consumers. So
yes.
That'll be interesting.
Well, and you also,
go ahead.
Sorry to interrupt. I just wanted to point out that there is a question about whether or not the term consumer includes employees. And the definition of consumer is broad enough to include a company's employees. So they're trying to get some guidance on how that really affects the employer-employee relationship and the data that they have to have. But there are sufficient exceptions to, say, the deletion of information that most employee information will not be affected.
Wow, that's very broad ranging.
Yeah.
Yeah. Well, thank you. This has been most enlightening. We really appreciate you taking the time and hope to hear from you on future webinars.
Thank you most kindly. I appreciate it.
Okay, thank you, Paul.
Thank you.